SJC-13655, City of Newton versus Commonwealth Employment Relations Board.
Okay, Attorney Zawada.
Chief Justice and Associate Justices, may it please the Court, my name is Jacqueline Zawada. With me is Jennifer Kelly. We represent the City of Newton. I intend to elaborate on 2 points today. The first being that the record in this case specifically did not establish an adverse action because there was no objective evidence of a disadvantage, in the terms and conditions of the sergeant's employment as a result of the transfer. And the second point being that per this court's prior decisions, performing satisfactorily is part of the prima facie case for retaliation under Chapter 151B, and therefore, if we look at 150E and the requirement that there be a generally good work record, we can see that these requirements are akin to one another.
Can you address the work hours, the Monday through Friday kind of 9 to 5 position versus the role of a supervisory sergeant with the crazy schedule and the half days?
Absolutely. And I'd first like to start by acknowledging that, when we look to an adverse action, the cases make clear that we look, I think it was the Yee decision by this court, that makes clear that we must look from the perspective of a reasonable person in the plaintiff's shoes. So we must consider a police officer as opposed to somebody like myself who works 9 to 5. So this is a reasonable person in the police sergeant's shoes must consider whether there was an adverse action. So to your question,
Meaning police officers don't like to work during the daytime too?
Yes,
and with their families?
In fact, on this record, it's an excellent question. On this record, there was testimony specifically from a captain who testified he was at the time a lieutenant. No lieutenants wanted to work days.
One of your witnesses testified to that.
No, a witness testified that he was forced to work days, and when asked why, he explained no one wanted to work days. All lieutenants wanted to work nights. And so we cannot, this is exactly why we cannot assume that the day versus night or weekdays versus weekends is necessarily adverse or advantageous for that matter. And so
When he gets up, he's not going to recite anything from the complainant to the contrary?
He is. And you're also not giving us the framework. The framework is the deference that is due. So let's begin there. So Justice Gaziano's point, you're about to tell me that folks get up there and say, a lot of people want to work at night. It's not necessarily day versus night. But there's direct testimony from Sergeant Babcock who says, I've got a family. I don't have to work. And it's not just nights. The way the City of Newton Police Department is, you work the last half, you go home for 8 hours, and then you come back to the second half. So you only get 8 hours between, versus someone who for years had a regular, more humane schedule for someone who's got a family, 9 to 5 or whatever the shift may be during the day. He didn't have to work weekends. And he testifies to that. So when the board credits that and says that was an objective material adverse action, and the 8% is, and he testifies to that, the 8% isn't necessarily important to me. I know he said some things about I could maybe get details and make this up, and that wasn't very strong. But the crux of his testimony, which they credited, was, I don't want to work nights. I've got a family. I don't have to work weekends. I don't have to work holidays. I have to work during the day. How is that up? How can we go around that fact that they found?
I think how we make sense of it is that we must consider what the legal requirement is. And the legal requirement for an adverse action is that you need to have evidence, substantial evidence needed to show a disadvantage in the terms and conditions of employment, and it needs to be objective. And I think that the objectivity maybe is what we're getting at in talking about, in this case, the sergeant.
That's what they found. They found that.
Well, so in this case, the sergeant testified that my family life was affected and the money didn't matter so much, but that doesn't comport with the case law. The case law makes clear, no matter which of these cases you're looking at, an adverse action.
What was the objective evidence that it was not an adverse action? The fact that this lieutenant testified?
The strongest evidence that this was actually advantageous was the significant pay increase that this sergeant received upon transfer. There's no dispute that at the time of transfer, he received a pay differential of 8%. It was about $6,000. He admitted to this, during testimony. There's no dispute he received it. And we know in Yee.
So if you get paid enough to make the disadvantage tolerable, then the objective adverse action test is not met?
Well, so
you throw enough money at a problem, it makes something that is otherwise disliked by the average reasonable person into something that's no longer an adverse action.
Well, and that's where respectfully, I would disagree that this was disadvantageous, because on this record, yes, we have kind of subjective testimony, the sergeant saying, well, my family life was affected by this.
Right,
But we have
contrary
other-
to the
we have other
subjective
witnesses.
testimony of the lieutenant. And then you're saying that the tiebreaker, I thought that's what your argument was, the tiebreaker is that we threw money at the problem to make something that was otherwise unappealable, appealable.
Well, I would maybe disagree with the characterization that it was, that we have on this record evidence that the reason for the money was that it was unappealing to someone to work nights. We don't have that in the record. The record
But
is
you're
very thin to
relying
that.
on the money as an objective indicator that it was not an adverse action. And I actually think that the fact that the collective bargaining agreement came to an increase of 8%, suggests that the conditions of employment were objectively adverse in the nighttime, or this crazy schedule as Justice Georges was talking about.
Well, and I would say
Because we needed to compensate employees that were going to be subjected to this environment by an 8% bump.
we just don't have that on the record, respectfully. We just don't know the reason for the negotiation, right? The reason
No,
they
I'm
arrived
just looking at it objectively, right? I mean, you don't pay somebody more for a position, and it's a bargained for increase unless you need to actually compensate people for that position.
Well, I think, again, and this is not real on the record, but generally speaking, in the context of collective bargaining, right, there's a give and take. There's many issues on the table, right? So looking at the sort of singular night
So
differential.
what is the tiebreaker then
So
between
it
the
is.
two subjective testimony? Why is it the City of Newton's position that it was an error to credit the testimony of the complainant here?
And perhaps I'm splitting hairs. I would submit, the city submits, that it is the pay increase. That is significant, substantial evidence of an objective advantage to this individual. And then in the counterbalance, what do we have? We really have his testimony saying, well, it affected my family life.
Well,
The cases don't-
doesn't I think to dovetail on what Justice Wingman asked you, under the CBA, doesn't the pay increase indicate it's an incentive to do a worse schedule, to work nights?
Does the CBA state that?
Well, no, CBA, you're given this pay bump to work not 9 to 5, which to me was, we're trying to incentivize people to work to work nights in the second half, right?
Well, I mean, certainly we just don't have that on this record as to the nature of the reasons why this number was arrived at or why. But we do know that, yes, the pay increase was given. And so that when we look at sort of the totality of the evidence on this record. and
I guess that the bottom line is whether or not the CBA is the be-all, end-all, like the appeals court decision would have you believe.
Right.
Well, and I guess I respectfully disagree with the characterization of the appeals court's decision as sort of framed by the union and the board. They're very confined to the facts on this case. They note that, the appeals court's decision finds that it looks at the context, right, which is that there is a CBA between the city and the union here. There was no deviation from the terms and conditions. The bargain for differential was paid. And there was no other evidence on the record before it to show an objective disadvantage to the sergeant.
That's where I'm going to go back again to this, because independently, there's an issue with saying just because the CBA allows you to do that, it seems to would obviate anybody's retaliatory claims if all we get to look at and say, can the employer do this? But let me leave that aside for a minute. You keep saying that there's no objective evidence, okay? Are you saying that the board could not objectively say working Monday through Friday during the day is objectively and materially better than having to work nights from the last half, go home for 8 hours, and then work the second half, and that they can objectively say not having to work weekends and not having to work holidays isn't objectively and materially better than now being somebody that can be whistled in at night, on the weekends, and during the course, even without Sergeant Babcock's testimony. Are you saying that the board couldn't make, and they did make that, because they cited those reasons for why they said that there was a materially objective disadvantage, irrespective of the money?
Sure. So there's actually two good points I'd like to raise. The first is that, respectfully, the appeals court's decision is confined to these facts. They never, and I think they even state,
I'm
we're
not talking
saying-
about their decision. I'm talking about the board's decision.
Certainly. So I think it might help to compare to some other facts in other cases. I think the Friedman case is cited at certain points by the appeals court, by my brother in the briefs. Friedman, Ginger, those are actually cases that are cited to for this premise of, the daytime work, the weekday work is preferable. However, we need to look for, in those cases, for the evidence that they considered, which was tied to terms and conditions of employment. In Friedman, the complaint was that, yes, he had to work a night shift, but why did that affect him? He alleged that the training he received on that shift was by inexperienced technicians, and people working the days got better training, better education, I think is what the court framed it as. Similarly, in the Ginger case, those are the police officers who were forced to go from a straight night shift to a rotating shift. They mentioned, change in their schedule, but really the court, again, tied that to the terms and conditions of employment. They tied that to, once they had these rotating shifts overnight, they couldn't sustain part-time work outside of their police job. And they tied it to other elements that really affected their bottom line, their income, their salary, their ability to have jobs.
What about family life?
That was not considered, and again, I think that was not a factor in the conclusion that it was an adverse action, right?
But
it always needs to come back to the workplace and the work environment.
But our review isn't to compare and contrast what they did or found in another case. This is a substantial evidence case. And so we're looking to whether or not there's substantial evidence to support the board's decision. And I don't want to lose you before your time is gone. But so I understand that, and you were in the courtroom, and I think you know what our feeling is about citing footnotes in cases as the holding of them, like you do for this notion that you've got to show a good employment history in order to make a prima facie case, relying on the last sentence of a footnote in a case from. So you know how we feel about that. But you mentioned about the collective bargaining agreement, about why we don't know the basis for the 8% bump. There's another reason, there's another thing we don't know the basis for, and that's if you follow the progression of the test and assume they make the prima facie case, assume the city offers its reasons for why this was a legitimate employment decision. Let's go to the other part, right? So you have this part about where the city, at least to the board, at least as you went up the flagpole, did not make a showing that these reasons were legitimate. And the way that the city was going was by cobbling all of these different things and said, oh, it could have been the fight with the lieutenant about the detail, it could have been with Crowley, it could have been this, it could have been that. Wouldn't it be just easier to have an affidavit or testimony from Chief McDonough about this is the reason why I did this? And there was no evidence to substantiate that this was legitimate. I mean, that would have been the easiest thing in the world to do, and that wasn't there. And so the board said, we don't believe the reasons you've advanced. Why is that something that isn't entitled to deference?
Well, and I would first alert the court to this understanding that the city could produce evidence consistent with FORS, right? The burden on the city was to produce evidence, not to persuade. That ultimately rested with the charging party, the union. But it could rely on circumstantial or direct evidence. And this desire that the board expressed, that they wish they'd heard from the police chief, did not It wasn't a requirement that we produce him. And so what we do have on this record, though, is significant circumstantial evidence, right? We have the credibility of the IA officer who did testify, which the hearing officer relied on heavily, who also then testified further that he investigated, he spoke with the police chief, he actually writ the letter that ultimately came from the police chief.
But
and
all of
went
these
back and
things
forth
are
on it. So
asking
we-
them to read tea leaves, because they're saying, it could be this and it could be that, and you put it all together and it equals that. There's no direct testimony, because the only direct interaction we have is when Sergeant Babcock asks the chief, why are you doing this? And he says, essentially, because I can.
And that is on the record that conversation occurred, but we have other circumstantial evidence from which we could infer, and actually the hearing officer did infer that it was reasonable, and therefore the city's reasons were the correct ones, were the real ones, right? The reason for the transfer was that these two people could not work together anymore. They'd had this altercation, and it was highly credible in the hearing officer's mind, after hearing all of the witnesses, both Sergeant Babcock and the IA officer. She credited the city's reason, and it was ultimately on the union to persuade her, right? And so ultimately they did not do that, because actually the hearing officer found, well, the union's evidence was really temporal proximity. She found that basically there was protected activity, and then soon after this transfer occurred. But in the counterbalance, she had lots of circumstantial evidence to rely on, and that rang true to her. Whether it was, the IA officer and the letter, combined with, frankly, admissions from the sergeant that he knew things weren't going well with this individual. He was on a speaking basis with this person. In so many words, they couldn't work together anymore. So seeing that I'm out of time, I would just like to very quickly alert the court to two citations, if I may, relating to that generally good work record. The first is Syed Corp. versus Klein at page 707.
What year is that?
Syed Corp. versus Klein, that
You've
is,
got some really old cases here to come up with this standard 380 kinds of cases. Is this we've actually used this language in the modern era?
so Syed Corp. v. Klein was a 2011 case. It was a 151B retaliation claim, and it's actually cited to by the appeals court, which is why I bring it up.
It's an SJC case?
Correct,
And it's a 2011 case?
yes.
What's the full site?
And so, 459 Mass.
It's in the brief.
697. It is in the brief.
Yes.
And at page 707, that court lays out the prima facie case for retaliation under 151B, which includes a causal connection between protected activity and adverse action. But I bring this up because at 707, actually, the court explains that causal connection can be inferred where, among other things, the employee is performing satisfactorily, which I would argue is akin to the generally good work record here. Which brings me to my second citation. If the court would just humor me and look at footnote 4 in the Forbes case, that is where this court, again, it is a 1982 case, I believe, and it is a footnote.
81.
But the court does mention that, again, they're analogizing to the Title VII and the 151B process, and they're talking about how under Title VII, a plaintiff must be qualified. That's part of his prima facie case, and by analogy, that's why they've required the generally good work record under 150E.
And,
So
and we said might.
it said
might-
might, and then
might.
respectfully, in Southern Worcester County, they held that the teachers affirmatively proved their prima facie case because they proved it, generally good work record. So thank you for your time.
Thank you. Okay, Attorney Sunkenberg.
Good morning, Chief Justice, Associate Justices. My name is James Sunkenberg. I'm appearing on behalf of the Commonwealth Employment Relations Board this morning. I'd like to bring us back directly into 150E, and I'd like to start by noting that sections, not just Section 6, Sections 1, 2, and 6 of Chapter 150E expressly identify hours of work as a term and/or condition of employment. It's been specifically carved out by the legislature. The only other term and/or condition that is expressly identified in all three sections are wages. So wages and hours, we know under 150E, are terms and conditions of employment. Changing them in the way that's been changed here significantly from the day shift Monday through Friday, as we're talking about, to the last half, first half, overnight. That's objectively and materially a change to terms and conditions of employment, regardless of what the collective bargaining agreement says. I think then what we have to consider is whether it's objectively disadvantageous to a reasonable employee in that position. That's a sergeant who's got 30-plus years of service to his community, who is on the back end of his career, who has positioned himself for 6 years prior to the adverse action to work himself days, Monday through Friday. And as we've noted, that's a schedule that's conducive to a stable family life. And the change that he's been put is just not. So the board's position is that it's subjectively disadvantageous.
Let me ask you, maybe this is an add-on to that. There's the argument about the special assignment, that he's the traffic guy. That's a subjective.
The
I don't-
specialty assignment, yeah, I mean, I don't think the board hung their hat on that. I think they're more
I would hope
focused on the
not.
change, but it is a part of the change, yeah. He's going from a specialty assignment.
Right, but that seems to me to smack of some subjective view of their job as opposed to wage and hour.
Yeah, well, I'm trying to focus on the hours.
I know for good reason.
Yeah, I don't think, and I don't think for good reason as well, I don't think the board was particularly hung up on the specialty assignment aspect of it. It is there, and he's going to patrol. But we're really focused on the hours themselves constituting the change to his terms and conditions. As far as the collective bargaining agreement, which obviously we have to deal with, I would respectfully suggest that the rule that's been announced in the appeals court's decision, that we have to measure whether it's a change against the contract, is untenable. It's unworkable. First of all, the cases that are cited, Yee, Note 8, and Somerville. Somerville's a bargaining case about retiree benefits. And the pages that are cited even include a discussion of the interplay between Chapter 32B, Section 9E, and the conflicts section of 150E, Section 7D. It just doesn't have anything to do with adverse actions. It doesn't contemplate it at all. And then I think it's worth considering, I would ask the court to just consider how we would apply this rule going forward. How does it apply to a just cause scenario? Just cause provisions are protections, they're benefits that are negotiated into contracts. Does the fact that the parties have negotiated a benefit, it directly limits an employer's ability to take adverse action. Does that make a just cause discharge not adverse? I think the rule starts to run into some trouble when we try to push on it a little bit. We know from the Board of Selectmen and Natick case, which is cited in the materials, that a just cause discharge does not preclude an inquiry into whether there's been a statutory retaliation. And that's kind of what we're dealing with here. The execution of this differential is not a waiver of a statutory right. And that would seem to be, regardless of whether it's intended or not, I think that's the implication of what the appeals court has done here. And so we respectfully disagree with that.
Could you move to the next two?
Sure.
So say you win on the adverse employment action. So we've got these two other arguments. The second one is satisfactory performance. And there is language in MOLE, which is relied on in the psych ed thing about, there's some, although they're usually talking about, if you've got a terribly performing employee and they get fired afterwards, we're not going to, read this requirement into we're not going to do this. But what do we do with this satisfactory language?
Well, I think it's as we've noted in the discussion already. It's never been required. There's the footnote in Forbes that I guess this all springs from. That note has been reiterated multiple times, but it's never been elaborated on. And I would note that we do have a decision from this court, town of Brookfield, 2005 decision, I think, in which one of the discriminatees, there were three in that case, the one who there was direct evidence of, his name was Graupner, Sergeant Graupner. His work record was considered as part of the stage 2 of a direct evidence analysis in that case by the court. It's commented on in the decision. It's never been required. If it were, it just hasn't been. As far as that aspect of the case goes. As far as the other aspect, to the second part of your question, the board correctly applied the standard as is articulated in Forbes and all of the progeny from it. Actual motive, it's a two-part test for stage 2. Actual motive, there's got to be evidence of something. I respectfully disagree that with the appeals court's characterization that the board was requiring direct evidence. It never said it required it. It did reference testimony or documents. But it's entirely conceivable that a situation could arise.
understand where we are. If we agree with you on point one, that there's been an adverse employment action.
Then the prima facie
and-
case is met.
Bear with me for a second.
Yeah,
And we
sorry.
even agree with you that the satisfactory language is sort of vague and not really. But then we get to was there a legitimate reason posed? And the appeals court may have gotten that correct in that it's just a burden of production. But the board doesn't do that, right? Does the board do what, the appeals court says the board got that wrong, and they treated it as a burden of persuasion requirement. So then this is a remand? I'm just trying to get a sense of, if we agree with you on point one, and we agree with you on point two that the satisfactory language is being taken out of context, but we agree that the appeals court was right, that it's dealt with at the second stage, and it's a burden of production point alone. Is this, what happens? What?
Well, if it's a case where the board got that wrong, and I don't agree that we did get it wrong, yeah, then, I mean, Fowler, the Fowler case was a remand, where they said you don't have to require.
So are you saying the board did the burden of persuasion production thing correctly? Because I thought it is a two-part.
So I have the language right here.
Okay.
Let's see. The Forbes analysis state a lawful reason for its decision and produce supporting facts indicating that this reason was actually a motive in the decision.
But that's the
actual
third-
motive is what the board is looking for. That's what they're saying. There's no evidence of.
Isn't
It's a
that
black
usually
hole.
a stage 3 analysis that requires a jury?
Stage 3 is there's no jury. It's
I
but
understand-
for.
But I understand that, but isn't this normally left to well, maybe not. Okay, I'm thinking of the employment discrimination context.
Yeah, it's important to keep in mind, we are under 150E, and although there's some overlap, they are separate. Stage 2 is the employer's burden of production. The board has not attempted to shift that, and we do have discussion of this in the School of Boston case that's cited. They are not saying you have to persuade us. They're saying there must be some evidence, and they're not requiring direct evidence. They're saying there must be some evidence. And the evidence that what they're saying is that the hearing officer incorrectly applied the facts that she found to the standard. They're saying your credibility determination about Lieutenant McMains, that he was truthful, that he didn't harbor anti-union animus, just does not bear on McDonald's decision-making. He wasn't the decision-maker in this process. And it's important, I think, to keep in mind that in the labor context, discipline is not doled out in a piecemeal fashion. There is an incident that happened, the Crowley incident. There's an investigation. There's a personnel action that's taken. There was a reprimand. The transfer was not part of that personnel action. It came later, a month later. And as the appeals court appears to have overlooked, there was an intervening instance of a display of anti-union animus on April 9th in the response to the March 30 grievance, which the Chisholm grievance. All of it taken together, I mean, they're saying there's no evidence of actual motive, whether direct or circumstantial. It is possible to conceive of a situation in which, say, testimony about a pattern of practice in the back. We always transfer people when there's an altercation with a subordinate. That would be circumstantial evidence. That would likely meet the burden of production. It's not met here.
Okay,
Thank you.
thank you. Attorney Shapiro.
May it please the court, my name is Alan Shapiro. I represent the intervener, the Massachusetts Coalition of Police. It's Newton Police Superior Officers Local. I'd like to just speak to one of the issues that, to me, is kind of a red herring. The idea that an employee has to have a clean work record in order to be discriminated against. Now, I know the dicta in Forbes, and it's been brought out in some of the cases, it's raised, but I don't think there's any case where a court, an agency, said that this person is a victim of discrimination, but because they don't have a good work record, we can't fine for that person. So I don't understand why, in Sergeant Babcock, for instance, okay, he had a reprimand in, as far as the record shows, in 30 years of being a police officer, he gets a reprimand. That's not something that can be grieved and arbitrated under the collective bargaining agreement, which only allows just cause protection for suspensions, terminations, demotions, which mirrors the civil service law, where you can only appeal a suspension, termination, or demotion. So if there's just nothing that says that you can't have any impurities on your record in order to be a victim of discrimination, regardless of the context, whether it's union discrimination, race discrimination, whatever it may be.
Attorney Shapiro, can I ask you another question about the prima facie case?
Sure.
Does the recent Supreme Court case, I understand it's not this particular context, does that change our aperture about finding in the prima facie case the adverse action here?
Well,
because the
Muldrow,
Muldrow says,
no, I understand.
yeah, the Muldrow seems to suggest that it's not much, but the phrase that jumped out in Muldrow to me was that some disadvantageous action. So does that make it?
Well, I mean, that, of course, is decided under Title VII.
It is, but
believe.
we've talked about how these have kind of infused some of our.
Certainly, we would be glad to do that, you know, as far as 150E. But candidly, I don't know that we can say that as a matter of law, that this court is obligated to adopt a looser standard.
I appreciate that. That was something that people had bandied around it. Thank you.
Yeah, certainly. One other point I wanted to bring out is the appeals court seems to conflate two provisions of Chapter 150E. Section 10A3, which is the provision that we're dealing with as far as in discrimination, adverse action, says that it's a prohibited practice to discriminate in regard to hiring, tenure, or any term or condition of employment. So that's a pretty broad statement as terms of what are the areas where somebody can be a victim of discrimination. The court then, in the appeals court, they looked at Chapter 150E, Section 6, which lays out essentially the what is a mandatory subject to bargaining: wages, hours, terms, and conditions of employment. That has to do with what can we negotiate, what can we put into a collective bargaining agreement. 10A3, however, is much broader than that. Just discriminate in regard to hiring. Hiring is not a mandatory subject to bargaining. Tenure, if you're dealing with teacher tenure, that's not a mandatory subject to bargaining. That's covered by Chapter 71, Section 42. So I think there's a conflation here of these two provisions of Chapter 150E.
Before you leave, can you address the last paragraph of the appeals court, the stage 2? It seems it's a dicta. The court says it's dicta, but I'm just trying to understand how it plays out in this case, if that's correct.
Let me look at it.
This is the stage 2 that they've conflated what should be in stage 2 versus stage 3. And the SERB says that they didn't meet their stage 2 burden, and the appeals court says that's wrong. I'm trying to understand where we are at the end of this case.
So I think the employer, once the employee union makes out a prima facie case, now the burden shifts to the employer to come with some reasons that it could have been the basis for the alleged discriminatory act.
Right, and the appeals court says that that when the altercation with the other patrol officer meets the stage 2 burden.
Okay.
And that
But
seems correct.
I don't think that's correct. Because I think the case law says that,
I'm not saying it meets the final burden, but I thought it met the stage 2 burden, but is that wrong?
I think that's wrong, because I think the stage 2 burden is not only to show that the employer had a legitimate reason, but also that that reason played a role in taking the action that's alleged to be discriminatory. I mean, that's in Forbes. It isn't enough just to say, well, Sergeant Babcock, he argued with the lieutenant about details, so that could have been a reason. But you have to show that that was, in fact, part of the consideration.
Yeah, it may be just, I'm caught up in the pretext plus and all the employment discrimination stuff. Is that what the appeals court has sort of gone into that world here improperly, or is that what they're doing? I'm just trying to figure out what we do with this.
I think the appeals court is trying to create a basis in which it could show that the employer met its burden in step 2 by drawing from the record things that could have been legitimate. But there has to be evidence that those things were considered. And there's no evidence. I mean, Lieutenant McMahons, who testified...
The timing, we often focus on timing as evidence. And this happens right after the altercation with that patrol officer, right?
It also happens at the same time that the union had a case pending regarding a captain who was forced into a fitness for duty examination, where we ended up in the appeals court, which affirmed the decision of the SERB that there was an unfair labor practice committed. So, I mean, there's a lot of antipathy in the record between the chief and Sergeant Babcock.
So, in your view, what is the result here exactly? If we agree with you that it's an adverse employment action, and we agree with you that this satisfactory performance is not what we meant to say in these earlier cases, that it's a precondition that has to be proved, what happens here?
Well, I think that the employer fails to meet its burden in stage 2. And therefore, I
But then
think,
you're buying it, I thought you said that stage 2 means, in your view, has to be, the way SERB said, it's the actual reason.
it doesn't have to be the actual reason, but it has to be shown that a legitimate reason was considered as part of the decision and not just taken out of the air.